right? So you're like, we're almost like restating the definition of a social equity business by putting in SCP and EEA. But my only, just an unintended consequence, if we remove it, is according to statute, a social equity business or marijuana establishment with not less than 51% majority ownership of individuals. And I think folks have brought up in the past that that's a barrier, the ownership in controls to selling or creating generational wealth. So if we lock in SEB everywhere and eliminate SEP, EEA, then according to statute, an SEB must have 51%. And I think folks wanted to address that down the line about the 51%. So I'm just flagging that. I'm just flagging. That's all I'm doing.
Thank you again, and thank you, Commissioner. And as I have, one of the things that I hope that we, as a commission, will do moving forward is to create. And I think that Andrew and Mercedes' right eyeballs will be twitching, but that we should create, in essence, almost a standing group over the course of the next several years to allow us to quickly not open up regs, but have constant regulatory updating, because we think that there's quite a bit for us to do. And as problems such as hearing currently from social equity business, entrepreneurs, that they're now looking for an exit opportunity for transformational wealth or generational wealth for their families. It is something that we will have to address, Commissioner Roy. So again, not that it comes in here, but it's something that I think we all have been hearing from people over the course of the last several months, and something we need to address in the future. So thanks. So I think that Kyle offered some excellent language. Attorney Carter, do we have a thumbs up that you have that you think it's workable?
Excuse me, Madam Chair. Yes, I have the language. I will circle back with Director Potvin just to ensure that I have each piece as we are moving quickly. But I will make sure that I have the language.
Thank you. All right, and B, including goals, programs, measurements. Again, I already read that, no questions there. Moving on to number 3, a host community shall publish data regarding its total applicant pool, which shall identify each social equity business and license applicant that has been designated as a social equity program participant or economic empowerment priority applicant. B, a municipality or host community shall adhere to best practices for host community agreement negotiations with license applicants that have been designated as social equity program participants or economic empowerment applicants, including but not limited to the following. Now, again, if I can just stop myself here, is this where we also need to streamline our definition, or what do we need to change when we're trying to open up that accessibility of that pool? Is that something we need to do here, or are we, and again, I apologize for my confusion, is that something that we will develop consistent language that every place it goes?
I think you're right, Madam Chair. This is another section, we want to maintain that same effort and intention. There should be a tweak here that allows people who we anticipate will be SCPs, right, and not EEAs, but SCPs, that this is where we can expand that window as well. I'm trying to think of what that language should look like.
Well, that have been designated, and
is this a place where we could say may be eligible or have been designated?
Yeah,
I pose this question to the
may or have been designated. Does that work?
May I ask a
Attorney
question?
Lopez? Yeah, please.
This is a question for the chair and Commissioner Concepcion. When you developed this idea of the standard evaluation form, were you thinking about applicants, or were you of the impression that pre-verified individuals would be engaging engaging, will have already submitted an application with the town, I guess.
Let me
Can you
tell
say
you more, let me tell you what broadly we were anticipating, that and this was when we went back and forth about the definition, and the legislature used the term business. However, what we're addressing are many groups that may be stepping up to the plate. I'd like to apply. This is my plan, you know, and they may be at varying stages of licensure, of becoming incorporated or whatever, but I have a plan. I want to do this. And I am, you know, asking for this host community agreement. So this was where we were kind of looking at the language that the legislature was telling us to do, that social equity business had a certain set of assumptions, but we felt that if we are meant to be dealing with at the very, very earliest stages of the approval process that people go through for zoning, for host community agreement, that what actually is a social equity business may not be the correct language that gets at the goal. And I don't want us to be doing something that the legislature is not telling us to do, but if it's all directed to these very, very early stages where they feel that people have been left out, elbowed out, not knowing the right people, that business is a definition, but it needed to encompass those additional people who may want to get into this, but may not have the level of there to meet that hard definition. Does that make sense, Attorney Lopez?
It does. The reason I asked is because subsection B is about actual HCA negotiations. And so it
Mhm.
seemed to me that the negotiation stage of this would likely be happening once someone's already a licensed applicant, but maybe not. But I just wanted to make sure that was
Sometimes not. And I'd ask Director Potvin to chime in, because some people start this very early in the process, you know, maybe even before they've filed for licensure, but I'm not sure if I'm stating that correctly. So Kyle, if you could kind of weigh in and answer that question, I'd appreciate it.
Thank you, Madam Chair. Again, this could have a couple of different permutations too, but I think you're right. There is a situation in which I think predominantly it will be licensed applicants, to Rebecca's point, but let's use an example of a licensee that's operating in a municipality, and now they may want to change their location to a new town. So they're a licensee.
Mm-hmm.
And if they hold those statuses that we've outlined through these policies, that could be a leg up for them.
But
So
what I'm not sure, but I think that, and maybe I'm missing it, is it that when you're, you know, I have an idea. I'm in my hometown. I have an idea. I want to file. This is my business plan. This is what I'm going to do. I'm going to go through this, but I may not have begun the official licensure. May not have filed anything with the Cannabis Control Commission. That happens, right?
That does happen.
Yeah.
And as of today, you need, in order to submit an application for initial licensure,
right,
you would be required to already have that HCA in hand.
But that's what I'm saying, is that this is where it begins. Although I have seen it in parallel, this is where it begins.
That is predominantly where it begins. But the situation that I was throwing out that encompasses the other aspect of this is not so much a licensed applicant, somebody who's already been issued a licensee, maybe even is commencing operations in, say, a place like Worcester. And now for some reason or another, it's not advantageous for them to stay in Worcester, and they're looking to, say, move to Framingham. But they're a licensee who now needs to negotiate an HCA with the city of Framingham. And if they're designated as a social equity business economic empowerment applicant or social equity participant, this latitude in addressing both licensed applicants and licensees would also address to them when they're negotiating with Framingham and also for Framingham.
Okay. So Attorney Lopez, if you could just, are we good here? Do we need any edits here, knowing kind of the bigger picture of where we wanted to get to?
So if the policy purpose is to include individuals who may be eligible for either of those designations, then what you could do is you could say a municipality or host community shall adhere to best practices for HCA negotiations with licensed applicants that have been designated as social equity program participants or economic empowerment priority applicants, comma, or who have been pre-verified pursuant to, and then we identify the regulatory provision that speaks to pre-verification, comma, including but not limited to the following.
Thank you. Okay, so I think we, Attorney Carter, did I see your hand going up or your pen waving?
Yes, thank you, Madam Chair. I was just hoping that Councilor Lopez, could just repeat what she said, just, to make sure that I have adequately captured it.
Of course. So in the regulatory language, Attorney Carter, after the capitalized term economic power empowerment priority applicants, we say comma or have been pre-verified pursuant to, and then we've referenced the regulatory provision on pre-verification, comma, including, and then continue the sentence. So it's just a clause that links us to that pre-verification.
Thank you, Councilor.
Okay, are we good? Commissioner Camargo? Oh, you're good.
Yes.
Oh, you're, okay.
So Madam
We've
Chair.
got to
I'm
get our
doing-
hands, we got to get our hand signals here. I know one that I definitely will recognize, but I don't want you to use it on camera here. But there are emojis for that. But
know.
anyway, do
Madam
you have any
Chair.
other questions?
So I don't have a question on this, but I wanna, before you move forward, I kind of want to pause a little bit because I have a lot of questions on this section.
Oh,
And
please.
And
You
it's
mean
a
the
lot.
next section, the next section coming up?
Yes, but also I want to go back to number 3. So I didn't want you to go too far. I mean, you could do two. Oh, shoot.
Oh,
You could
it's
do
okay.
two things.
You
You
no,
could-
no, just raise your issues. I don't want to be
Okay.
getting, so number 3,
Okay.
let's get to that.
Okay, so let me get my screen up. So I'll try to do this in a few buckets so that I don't overwhelm anybody. So number 3, sort of going back to number 3, a host committee shall publish data regarding its total applicant pool, which shall identify each blah, 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 da, da, da. So kind of putting a pin on that, it makes me think about a data section. So I'll pause there for a second. And then we move down to number 1. And I know you haven't read this yet, but a host committee shall develop a standard evaluation form that scores.
How about this? Let me run through that part and then we can address, because if
Okay,
you
go ahead.
want to, all right, because again, I don't want to be doing this and not having,
Go
you know.
ahead.
So anyway,
Go ahead.
okay. So a host community shall develop a standard evaluation form that scores components of an application. The evaluation form shall include consideration of equity in the overall evaluation score and must comprise not less than 25% of the total evaluation score. This equity component shall include Romanet 1, whether a licensed applicant is pre-verified as a social equity business by the Commission. Romanet 2, whether the licensed applicant is a social equity program participant. Romanet 3, whether the licensed applicant is an economic empowerment priority applicant. Romanet 4, whether the licensed applicant has a prior marijuana-related criminal conviction. Romanet 5, whether the licensed applicant is part of an area of disproportionate impact as identified by the Commission. Romanet 6, or Romanet 6, a majority of a licensed applicant entity is comprised of individuals from Black, African American, Hispanic, Latino, and this is a substantive change, or Native American or indigenous descent. And are you going to cover anything in 2?
Not right now.
Okay, so why
But I
don't
have
you
a lot.
address?
Okay.
Okay, go ahead.
Thank you. Okay. So I guess I'll make my comments and then maybe you, again, Commissioner Concepcion, I think you said it earlier, right? We weren't in your group. So I appreciate this, the outcome of it, right? But I don't know the thought behind it. So when I read this, it's a lot to unpack. So I have a lot of questions around the Romanets, but the big bucket that I just want to talk about is sort of a data collection sort of bucket here. It sounds like there's a lot of data to be collected. And then it says a host community shall develop a standard evaluation form. So I guess my question there is, and just, I've ran a lot of grant programs. I've seen rubrics and metrics and scoring sheets and, all that. And I think about if you all thought about allowing the CCC to create a standard form for all municipalities. One, to have one standard form, one, so that when when it's coming to anyone, it is one standard form, right? We can sort of compare apples to apples throughout the state. Two, it allows us to collect the data that we're sort of talking about, plus maybe any other extra data that we may sort of think about. And then also just for the reason that we know that access and capital allows you to buy the best grant writers or the best consultants that will then tailor, the application to get the highest scores, right, in this process. So all that went through my head, sort of looking at this section. So I guess I'm also did a little bit of research, and that's what I sent you all, which was the delivery data that we collect, that we're supposed to be collecting. So I could talk about that in a second, but I guess my bucket is a data collection section, but most importantly, us, the CCC, creating a standard form. And then I'm also thinking that once all this data is collected and there is a standard form, it's even easier for us and our team to create some kind of dashboard, or it become part of the open data, or it be like sort of our licensing tracker that will then allow everyone to see everything throughout the state. And I guess, I don't know if you all sort of had the conversation or talked to Dr. Johnson or Dr. Scarts, on our team. But that's my pause on a big level. And then I have some sort of granular questions around the Romanettes.
I don't disagree with you. And frankly, we have some, we have public information databases that, the issue is, well, if you put that up there, it has to be updated. And for instance, we talk about the standard, what communities have, whether or not they allow cannabis, that making sure that list is up to date, frankly, helps social, equity potential applicants find communities that may still be open territory to do business. So, I think about the impact, but I absolutely think you're on the right track, that this is a good idea, that we need to create both consistency as well as automatic transparency. We will hear that this is an impact issue, because again, I know for a fact that the public data that we have provided for different communities and the rules that they have in place, again, this is not something that we sort of dedicate a lot of resources to collecting. We ask communities to send it to us, but we probably can do something, even with the MMA to improve that. But one, I agree with your idea. I think it's a good one. But I right here today, in terms of developing language, maybe it's just shall develop a standard evaluation form, or use one, one created by the Cannabis Control Commission. Maybe we can just throw that in there. What do you think? Go ahead, Commissioner Stebbins.
Yeah, no, I appreciate this discussion, and I kind of some thoughts that I'm thinking about is, we've talked about, in the previous HCA, creating a model HCA that, communities can use. I guess I'm a little concerned of a standard evaluation form. There might be a host community out there that wants to evaluate their applications, not just based on, some of the social equity piece. And maybe I'm thinking the definition of the evaluation form is too broad, but they may also want to condition their application on how do you hire locally? Are you going to be energy efficient? Some of the other things that we're looking in the industry. So I'm capturing the question of whether the evaluation form itself might in fact differ community to community, even though we want them to build in, the a piece of their application having, some assessment of their success reaching, scoring social equity or EE applicants.
And again, we've used Somerville in our memo as one, community that has already done a good job of being transparent and including equity, but they absolutely include. So again, I don't disagree with you. So maybe, again, they still have the option of creating their own, right? So it's kind of an either or. Is that what you're thinking of, Commissioner Camargo, or do you think everybody should have to?
I mean, I think, and I appreciate Commissioner Stebbins' comments. I think, and I don't know who on our team here, whether Dr. Johnson or Dr. Marianne Sarks is around to kind of have the conversation, but I'm putting it out there just because I hear what you're saying, Commissioner Stebbins, in terms of like there's extra information that they might want to collect, which is fine. But I think about compliance. I think about, this.
I think what
I'm
he said,
thinking-
excuse me, no, but I think what he's saying is
No, I know.
that they'll have individual.
Yeah. I'm sorry. Let me finish my thought. Just give me a second. I'm trying not to rush through this stuff, but
yeah,
the concept, I guess, is creating a standard form that we then can compare. I don't know, like, I'm bringing it to you all as a concept. We can think about it and talk about it a little bit. And I don't know what you all talked about, in your working groups, but I'm just thinking a standard form from the CCC in terms of the metrics, how they're evaluating, right? But they can add their own stuff.
Commissioner Concepcion, and then yep. I'm remembering some of our discussions, so I'll bring it back.
Go ahead. You might be thinking the same way I'm thinking, because I want to just provide some additional background and some additional context to how this was developed. First, I do think it's a good idea. When we were developing these regs, it was after having multiple conversations with existing licensees and understanding the process that they went through. And it's common throughout a number of different host communities to utilize a sort of scoring, rubric or mechanism in evaluating who receives a host community agreement. So this was done with the purpose of understanding what's happening now. We didn't want to create something really new. We wanted to identify the issues that we know are prevalent right now in the industry and ensure that equity was at the forefront and being included in these scoring mechanisms to a place where it didn't disadvantage our prospective equity licensees. So that's the reason why we have that here. In terms of the CCC being the creators, at least for a baseline scoring mechanism, I think that's a good idea. I hear what you're saying in terms of for data collection purposes, for sort of streamlining our own intake, but also making that information publicly available so that people are able to identify sort of what different municipalities are doing and sort of ensuring that these equity provisions are followed. I think that makes a lot of sense. What might be something we consider is that we do develop that, but then like you were saying, I think you were saying this, Commissioner Camargo, is that we sort of add like an open-ended component of that scoring sheet where municipalities can then inject additional provisions that they look for. So it's not exclusive to the terms that we require or what we're stating, but there's still flexibility to, that speaks directly to the uniqueness and distinctiveness of each municipality in the Commonwealth.
Yeah, and I think that gets the Commissioner Stebbins' point, right, as well, in terms of there may be some local stuff, but, on the flip side, then and I don't know how this happens, but then it allows us to create, like we have a section here. Let me just read it really quickly. I think it's just number 3. a host community shall publish data regarding its total applicant pool. So, they're going to publish their own data, which is great, according to these regs. But I think, it'll also allow us, and kudos to the open data platform that allows folks to see it. But we could then create sort of an equity dashboard throughout the licensees and stuff like that, if we are able to create something standard. And then so that's sort of the one piece of it. I don't know if you guys want to pause there to discuss that a little more. I don't know, Attorney Carter, if that is part of the scope that can be discussed after public comment. Is it something we discussed today? How does that work?
And I
Because
also
that's
saw Kyle's head pop up for a second, so I didn't know
Okay, go
if
ahead.
Director Potvin
Yeah.
wanted to add any things, but I just wanted to note that I did see him. I don't know if he wants to, because this will have an impact, and I don't. Okay, I'm looking at your face, or maybe not.
So,
Does-
Attorney Carter, I guess was my question for something like this, because I have other questions, but before we keep moving, I just want to make sure, Madam Chair, that Yeah.
Could I suggest, because I think that there's a lot of practical consideration here that I don't know if we have enough time to fully vet this right now, and because we're up against the deadlines, I get a little bit nervous because I think it's a good idea, but I want to figure out how it's going to function. So if we can figure out some language that notifies the public we're looking at this, and then during the public comment period, we can seek out input from municipalities. We can talk to, our team to see what that impact is going to be. But I would suggest, if you think that this is appropriate, shall develop a standard evaluation form, or utilizes one developed and published by the Cannabis Control Commission. And if we throw that in there, it in essence is notifying the stakeholders that, oh, this is something we're thinking about, and they can say, yes, this is a great idea, and no, this is the worst thing you've ever told us to do. But would that satisfy you right now? Because I feel that this is something that's very substantive, and even some of the databases that we utilize right now, it is work to collect that in. Some of our databases have been not up to date. And I'd like to understand, I think they should be, because I think that lowers the barrier for some communities to know, where do I go, who's friendly, who's not friendly. But I just want to make sure that in terms of the process of getting through the day, we plant a flag and we kind of get to what you're trying to get at.
Madam Chair, if I may.
Please.
So I hear you. So a couple of things. One is I want to make sure that we don't sort of mix the two things, right? So one is the standard evaluation form from the CCC. The other one is sort of a data collection section within municipal equity. So I think those are two different things, and I apologize if it wasn't clear, but those are two different things. So I want to make sure. And I guess my question to the legal team is, we talk about scope. One of the reasons that we paused on 2 weeks ago was so that we could really read through this stuff and understand the scope. So I guess my question, Andrew or Rebecca, is how does this impact the scope? Because if it's something that we can throw in, like the chairwoman is saying, and leave it up to public comment, then that's one thing. And I'm okay with that as well. But I want to make sure that those two, like if we're going to talk about a data impact section or a data collection section and a standard form, how does that impact the scope after public comment? Does that make sense, Andrew or Rebecca? Yeah.
Yeah, Madam Chair, if I may.
Yeah, please, Andrew. Sorry.
Yes, Commissioner, I would suggest it is within the scope. I would also further suggest that this meeting is providing notice to the public that this is a policy consideration before the body. So if you are interested in incorporating the chairwoman's suggested edit, which allows either the municipality or the commission to, the municipality may develop a form, or they may use one developed by us. I think that could be a good jumping off point if there is further discussion or further contemplation after we receive public comment, and we may want to incorporate it.
So Commissioner Camargo, again, only because sort of the devil's in the details, and that I know that we have other databases. So I would want to sort of understand And unless you can tell me now what that mandated collection of data would
Yeah,
be, I mean,
so
are we
so
gonna
let
put
me,
in like a penalty if they don't
yeah, so let
report?
me,
So,
no. So let me go now to the sort of example that I emailed to all of you. Andrew, I emailed it to you. I don't know, you can put it on record. I looked it up. It's the same data that we collect that we're assuming that we're collecting for the delivery X activity period. So I don't know if you guys, I did send it to you all a little while ago, but I'm just going to say this. Yeah, I'm going to just say this out loud really quickly, Madam Chair, but we can look at something like the data collection that we're doing for delivery. So under 935 CMR 500.050, Section 10, Section B, number 4, I'm going to read this really quickly. The commission shall develop criteria for evaluating whether the goals of the X activity period are met, which shall include but not limited to, and then it goes through a couple of data points. And I'm only using, I want to make sure that amongst us, I'm only using this as an example of data, of some data collection. And some of it may already be in there, but I'm using it as an example. Overall rates of participation in the regulated marijuana industry by people from disproportionately impacted areas. Again, I know there's some of it is in there. Overall rates of participation in the regulated marijuana industry by people of color. I think it might be in there as well. Licensees granted to businesses with majority ownership comprised of EEAs, SCPs, etc. D, number of registered agents who are SCPs. E, number of delivery licenses in operation, that's specifically to delivery. F, I don't know about this one, financial feasibility of continued participation in the regulated industry, may not be part of our preview. G, any other information the commission determines relevant. The commission shall collect and report on data measuring throughout the exclusivity period. So that's just an example of the other bucket in terms of data collection that I was sort of referencing to. And we could think about some of the data that we're supposed to be collecting for delivery. So again, I think that Andrew, to your point, it's something that we can reference here that I would love for us to go back and talk to our research team and to our data team and see, how does this fit in? But again, I want to make sure that we talk about it today, so that's part of the scope. So those are the two things that I saw missing in that. Those are the two things that
Okay, Commissioner Camargo, the scope is fairly broad, so I think that we sort of understand that. I just want to make sure because, again, we do have a shortened timetable today that I think this idea is a good idea. I'd love to get some consensus of other people because I think that if I were to vote on this right now, I don't know if I'd want to include it because I want to kind of get my head wrapped around it.
It's fair.
But
Let me just interrupt you, Madam Chair, by me. Let me interrupt you.
Please.
So I'm gonna take a breather.
No, please. Yeah.
Because this stuff is really important. And I know that we don't have a shortened day today. We got to get through this stuff. We're on a deadline. So I get it. And you're right. We're not going to vote on this today. I respect that. But I think we can't run this meeting as if we're in a rush to kind of get it done. So there's a lot. I'm trying to get my thoughts out. I'm trying to speak. I'm trying to get, use the data, stuff that we have, use our team. So I just want to say that because this stuff is really important. And then we put this out to public comment.
Right.
We missed the scope, at least for me. I don't want to miss the scope. I have a big responsibility to the Commonwealth. So I just want to say that because this is a big deal. And people have been waiting for this for the last 5 or 6 years. So this municipal equity reg is a big freaking deal. So
exactly,
let's talk about it. Let's put it in there, whatever we can do to figure it out. Listen, you guys can vote me out, right? But I want to make sure that we talk to our team, we talk to our research team. You all led this group. And I thank you for it because this is a lot, but I want to make sure that we have the conversation. So
what I'm trying to do is accomplish exactly what you want, but because we are under a deadline and we have to move through this stuff today. And because we have already extended our deadlines. We have a deadline. Our working group has a deadline. And even with those deadlines, we had to extend those deadlines. So what I'm saying is today, we don't, if
No,
Anyone
no,
who
no.
raises, I'll call in tomorrow from my.
We're not
my
voting.
out of town. No, but I'm saying, if you would like, I said, we don't have time to notice it, but I think we've been told we don't have time to do this on Monday or Tuesday next week. And I know that other commissioners,
I get it.
I'm leaving today. I'm gone over the weekend, but I'll be back. I could do this on Monday. I have time. So my point is, what I'm trying to say is, if you are satisfied, we've heard from Attorney Carter that it's within the scope. Again, this is one of the things I thought we had talked about previously. The scope is fairly broad. It's like all of a sudden.
I get it. I get it. We
So,
can move
so I just,
forward.
as long as you're satisfied, I'm satisfied that we do this. I think it's a great idea, but I just
Yep.
want to see what's the language that you'd like to
Yes.
propose
We're on
that
the
we
same-
put
we're on
in
the
there
same
that
page.
holds it. Okay, all right, great.
We're on the same
Okay.
page.
All right,
We're on the same page.
thanks. So, and Attorney Carter, so can we, put in section, B subsection 1, a host community shall develop a standard evaluation form, or utilize one that is written or a model that is drafted by the CCC. Do we all agree that we put that there? Again, it's not perfect, but it allows us to get Commissioner Camargo's idea sort of in the stream of, debate and commerce, and we can look at that. Does that work for everybody?
Yes.
Does that not, Commissioner Stebbins? Yep, okay. So how do we get at the issue of data collection? Because again, and I didn't have an opportunity to talk, but we did talk about this, about data collection, that we have a greater responsibility to social equity to collect more data. And there has been a little bit of pushback, about how we do that. So, and I still want to make sure that we understand what would that data collection actually look like. Again, I am less aware of the stuff on delivery. So that, and again, I didn't get to read your email. So, but anyway, can we come up with some language that captures what Commissioner Camargo is trying to do? Put this in here, not necessarily as a placeholder, but reminding people that this is a subject that we would like to robustly explore. Attorney Carter, do you have any thoughts on how we can include that data section or data collection that she's talking about?
Thank you, Madam Chair. It's an interesting question, and I wonder, the provision, right, a host community shall publish data regarding the total application pool, et cetera. I wonder if maybe that's a place we could insert language, a second sentence such as, shall publish data to us as well, or is that the, I just want to make sure I'm understanding the underlying policy, which is, oh, please, Commissioner.
Yeah. Madam Chair, if I may.
Please.
Yeah, so I guess yes, Andrew, the policy question is, and I think that this is a bigger conversation, and again, I know it's hard that we're having it today, but I would love to get staff input on this. We have excellent research team and an excellent data collection team on this, so I think there needs to be sort of like a data collection, maybe a separate section of data collection. What does that look like? Again, I was using the delivery example, the data that we're collecting. So I don't know. So I guess, Andrew, to your point, I would like to get input from our staff, but also even from you all commissioners that were part of the working group. Is this something that you think is doable? Like, did you guys have the conversation? I think it's a good opportunity. I know it's a lot of work and it impacts the section, but I think in the long run, it allows us to collect and be able to even have more transparency out of the CCC. So that's the question. And if we can add the section and come back to it, Madam Chair, I'm okay with that as well.
Yeah.
Yeah.
And again, because I think we all would like to talk to the staff about the impact on how it would actually function, I'm afraid to put this in place because I don't know how this is going to function.
Okay.
So I want to just get the minimal language that you're comfortable with and then move on. And then we will have the time over the course of the next several months to fully vet this, to understand what our team can and can't do, and how we respond to their needs as well as the policy needs. Commissioner Concepcion, did you raise your hand? Did you want to make a point?
No, you got it. You answered something I was going to ask, so I no longer have a question. Thank you.
Okay, so Director Potvin.
Thank you, Madam Chair. To Commissioner Camargo's point, I think what I'm hearing from you as a policy request is that the host community is going to collect some variety of data on this based on that provision that's in number 3. And your desire from a policy is to be able to, the commission to be able to require them or may require them to report that information to us for us to then be able to digest that and also report that out. Is that an accurate reflection of what you're ultimately requesting?
Correct. Thank you for re-explaining. Yeah, thank you.
So, Madam Chair, as you were
Please.
saying, this is in the scope, and again, I will defer to legal on this, but I think an eloquent solution as a placeholder here would be a second sentence on that 3 where we're requiring host communities to collect this information, something that doesn't lock us in, but something that locks the concept in, something like the commission may require at certain intervals for host communities to report the information they're collecting to the commission.
Perfection. Do you have that, Andrew?
Yes, Madam Chair, we will put something to that effect.
All right, thank you. Commissioner Stebbins, are you pensive or are you waving?
I was waving, but I'm all set. We can move along.
Okay, all right, and again, and this was also just FYI, during the course of this conversation, and this I think will come up, there are communities like the city of Holyoke that have issued, and I think Uxbridge issued many more host community agreements than ultimately people will go into business, and they understand that, and you know that's been the prerogative of those communities. So one of the questions that we may have, and this will be hopefully during the listening and you know feedback period, that we reach out to communities like Holyoke to make sure this language doesn't necessarily require them to go back and look at 40 host community agreements, recreate their steps and do that. So we're going to have to figure out, this is going to be a more complex in terms of getting at the, I think, public policy goal that commissioners you know, Camargo and Concepcion, you know, have been focusing on. We're going to need to understand that impact. And I believe that we will get, again, I don't want to do anything today, but it is something that we don't want to put undue burden on communities that are mature and, you know, have done those things. And, but maybe we do, and maybe it's just an information gathering thing. But anyway, I just wanted to raise that we did discuss that.
Yeah, Madam Chair,
Please.
if I may, I'm not sure if other folks have questions in this section, but I have a few more questions for section.
Please go
number
ahead.
Okay.
This is meaty stuff. So
It is meaty stuff. So when we say the evaluation form shall include consideration of equity in the overall evaluation score, which must comprise not less than 25%. How many requirements will be needed to get towards that 25% of the score? And this is where, in reading this, is where I said we should probably create our own evaluation form. So can someone explain that?
I think that, again, when we looked at places like Somerville and Newton, that they, you know, they have a numerical score, and you know, some communities may, some may not, but we're basically saying strongly that there needs to be a numerical score, so that is how you can, in essence, look at apples to apples. So that in that numerical score, that however you score it, you may give 10% to, you know, being a local resident. You may give 15% to, and one of the things that we've discouraged is experience in the regulated industry, although we couldn't preclude that in including that in the score. But we discourage that because it may have a special negative impact on, you know, social equity applicants who may have been involved in the legacy market and may not be able to compete with MSOs. So it's trying to establish a numeric score, trying to say this has to be an important chunk of what you're considering when you issue host community agreements. But again, it's trying to make sure that we step delicately around the municipal autonomy to make these decisions, but to put in place standards that are measurable and accountable. Again, not every community will necessarily currently have a numeric score. And we're saying 25 is a number. We think it's a fairly significant number. And again, we didn't, it's just, we picked that. We thought it was important.
Yeah, just a pause for a second, Madam.
Sure.
I get it. I see what you're saying. And I think, again, I don't want to beat a dead horse, but this is exactly why my suggestion on us developing our own evaluation form for the CCC for municipalities to create that baseline for them. But I'll move on. I just have here, what if you meet one versus if you meet the other one? Again, I don't know what these scoring sheets will look like, again, which is why I'm thinking of a baseline. My other comment here is on Romanet, let me see, 3.4, whether the licensee applicant has a prior marijuana related conviction. When it says marijuana conviction, what do we mean by marijuana conviction? I think I know what it means, but I want to ask.
I'll ask Commissioner Concepcion because she was more intimately involved with this particular drafting part.
I'm a little confused by the question. I feel like it was very specific, but you can tell me.
Yeah, sorry, go ahead. Yeah, if you could restate that, Commissioner Camargo.
I guess Commissioner Concepcion, I was just thinking about the new tables. So I wanted to just be clear whether, I'm assuming that this is how we're defining it.
So this is not about stopping people. This is the opposite. So I think what you're referencing is our suitability tables, but this was extracted from the language we use for our SEP program, where we deliberately seek those who have those convictions on their records to participate in this industry. So that's what that language was. It was literally taken from our standards that we utilize in the social equity program.
Got it. Thank you. That background helps. Okay, so I think for this, for number one, majority applicants, okay, for number one, I'm good. Thank you.
All right, so can we move on, Attorney Lopez?
Thank you, Madam Chair. So I do think we need to rework the language for the Romanets to capture the individuals who would pre-verify versus having already been verified as social equity businesses. I don't know if you want to do that now or if you would want that to be done offline, but essentially, for example, number one, whether a licensed applicant is pre-verified as a social equity business, that would want to change to whether an individual or entity has been pre-verified pursuant to the regulatory section on pre-verification. And then I think for Romanet number 4, you would want to expand that to include, whether an individual, whether the individual or a pre-verified individual or licensed applicant has a prior marijuana-related criminal conviction. So there's some additional expansions that we need to include in there to cover that group.
Commissioner Concepcion?
Thank you. I just want to flag something that I just said, because clarifying that language came from our mandated language around rectifying harms caused by the prohibition enforcement of marijuana laws during the prohibition period. But in our social equity program, it's for drug convictions, not marijuana convictions. So I'll open that up to the commission in terms of if, the thought behind that was because of the equity mandate, but our social equity program states all drug convictions and it's not limited to just marijuana.
What is your question, or what are you asking us to react to? I'm not sure. Are you asking for a reaction?
I'm giving an additional response to Commissioner Camargo. She asked about the origination of the language around marijuana convictions. And so I went back into my notes. I've been on several different working groups, a ton of different meetings, but I wanted to make sure the information I gave her was accurate. So I went through the notes that I have, and I wanted to first clarify my statement about that being extracted directly from the social equity program, that wasn't correct. Our social equity program is for all drug convictions. It's not limited to just marijuana convictions. And the marijuana prohibition and enforcement stuff, that comes from our mandated equity requirements under statute. So I'm taking back what I've said and clarifying, correcting that statement. And then I was asking, in light of that, maybe not today, but we should definitely sort of look at that to see if we want it to be more aligned with that social equity program and the way that we have it there.
So,
thank you.
If I can, so Commissioner
Concepcion.
Yeah, thank you. Commissioner Concepcion, thank you for that. And I think that's when I was reading it, I think that's why what you're saying is what triggered me when I was reading it, because a conviction's a conviction, but which one, right? So, I mean, I think that we stick to the letter of the law, right? I think it's the marijuana conviction, right, is what we use. So that would be my suggestion, but I think it's key in this language right now.
Mhm. So what would satisfy your concern, or can we leave this as is? What would you suggest, Commissioner Camargo?
I think it's do folks understand what we're talking about? Because I think it's a conversation we should have, and or get some legal perspective on it. Let me see, like whether the license applicant is a primary one, criminal conviction. Commissioner Concepcion, do you feel that the language is satisfactory on here? I'm just bringing up the question, but I know you
I
have
understand
more
what you're
information.
saying. And I understood your question more after I looked through my own background. I
Yeah.
think that what we could do is just leave it for now,
Okay.
and then sort of, let the draft go in, open it up for the public comment period, but also
Okay.
internally, look into that a little bit more.
Okay, yeah,
That's
fine.
my suggestion, but
I'm
I'm
okay with
open
that.
to any others from the rest of the commission.
Yeah.
Do the other commissioners have any? Commissioner Roy?
Yeah, I just want to remind, and it's a great question, Commissioner Camargo, and that this commission asked our staff to rerun the numbers of the DIA report to include only marijuana offenses and convictions. So we did, that's what we did ask of our own staff to do that. So I just wanted to flag that and remind folks.
Thank you. So,
I'm okay.
Commissioner
One more
Concepcion?
thing. I would recommend that we not limit it to just convictions, that it be offenses and convictions. So I do want to throw that out there.
Okay.
Offenses, that's why I was thinking about the
So
table.
so Commissioner Camargo, does that get at your question or your
Yes,
issue?
it
Okay.
does, and I
So
think,
can
I
we
think
add
Commissioner
a-
Concepcion, yeah.
Can we add offenses? And I'm looking around the wheel here. Everybody think that is okay? Any legal attorney Carter, any pushback on why we can't do that or shouldn't do that?
Sure. And when we say offenses, does that mean arrest and conviction? Or I just want to make sure I'm understanding the word offenses.
Yes, offenses can go beyond an arrest because you're not always summoned to court based on an arrest. So when I'm saying offenses, I'm meaning a conviction means that there was a guilty finding, and an offense can happen regardless of there being a guilty finding or a non-guilty. It's a record. It's a criminal record.
Mhm.
So in essence, what I'm saying is a record for a marijuana offense, whether that be for the offense itself or a conviction that resulted from the offense.
All right, understood. Thank you.
Anybody else have any, Commissioner Roy?
Commissioner Concepcion, we talk about expungement and record sealing, and if that's expunged from someone's record or sealed, I don't want them to be, would they be precluded? In other words, do we need any language around those with even expungements in a sealed record?
I don't believe so, because that still exists. I will try to be brief because I can get a little long-winded when we talk about expungement, so I will not try to get that
I
deep.
asked you.
But that's the reason why there are concerns around expungement, is because you want to ensure that people maintain their records for themselves for instances like this. It's like you can still just make sure that's more of an awareness thing, is making sure that the individual has a record or documentation about what has happened, because that will satisfy the requirement. I hear what you're saying though, because there's definitely a risk there that if there is an expungement, that means that there has been an elimination of that record completely. So it does become, it's an obligation on that individual to provide information and be able to prove that they in fact have a record. So you're right.
Do we put that demonstrated expungement or,
No,
I don't know, I'm just throwing it out
Well,
there.
if I may, really quickly, Commissioner Roy, I guess just to remind us, this is in the section of data collection. So this is not gonna, exclude anybody. This is again in the whole community shall develop a standard evaluation form, just FYI.
Yeah, but as part of the evaluation, if 25% is weighted on this and
Right,
someone,
okay.
and it's not available to the
Yep.
scoring committee,
Yes,
I'm
thank you.
just throwing it out there. Do we
Yep,
need a
Perfect, yeah.
proof
I
of
agree.
expungement
Yeah.
or record sealing? That's all.
No, thank
And
you, thank you. Thank you for the reference, yeah.
Commissioner Roy, you definitely, you hit something there. That might be something that's better for guidance though. But you're right, that's important.
Okay. Anybody else? So we have, I think have we discussed this to the satisfaction? So just sort of bringing it back in terms of the language, have we addressed this issue satisfactorily, Commissioner Camargo? Okay, thank you.
Thank you.
All right. Okay, so I have gone through one. I'm going to address two. In circumstances where a host community imposes a cap on the number of marijuana establishments or MTCs that may obtain local approval to operate, if a host community later decides to allow additional marijuana establishments or MTCs, at least 50% of those licenses, but no less than one license above the previously established cap, shall be reserved for social equity businesses or license applicants that have been designated as social equity participants or economic empowerment priority applicants. Have we covered everything with our definition? And do people understand this concept and have any questions? Hearing none, I will move on. Host communities must adopt local
Just-
rules.
Sorry,
Go
Madam
ahead.
Chair. I just
Yep,
want to
sorry.
flag to make sure that we're all continuing to honor the policy intent of the group, that that the cap shall be reserved for social equity businesses, licensed applicants, and also those who have been pre-verified. I'm just wondering if that is the intention as well. If it is,
Thank
then
you.
we should add
Thank
that.
you. Yes, thank you. Thank you. Sorry, again, the designation and the we words. So anyway, thank you. Commissioner Roy?
Is this a presumption or a mandate?
Yes,
Which one?
it is a mandate, I believe.
Again, do we have legal footing to mandate percents based on the law?
Thank you. Attorney Carter, do you want to address that, or Director Potvin, Rebecca, anybody want to?
Sure. Well, I mean, what I would say is, chapter 180 has given the commission authority as it relates to mandates related to licensing. I believe the example you used earlier was mandates regarding participation. Yeah, in hiring. So I would differentiate a license context versus a hiring context.
Okay, thank you.
And again, it only comes in when there's a cap. And I'd raise questions because this is, again, one of the issues that I was concerned about for the later to the player teams and more rural and suburban. Okay, moving on. And again, just to restate, this is our first draft. We will get the MMA pushing back on us. We will get licensees pushing back on us. So, again, we're not going to get this perfect today. We just want to keep it and create a scope. The scope is very broad. So, there, we will be able to have another bite at the apple with more fully vetted input from different stakeholders. Again, moving to C, host communities must adopt local rules or bylaws to comply with this section on or before May 1st, 2024. A host community must submit an attestation in a form and manner determined by the commission, affirming that it has adopted local laws to effectuate compliance with this section and identifying the specific laws passed. Any comments or questions? Anything from our legal folks? Hearing none, we will move on. Any interested person may file a complaint with the commission alleging noncompliance with an equity requirement under 935 CMR 500.181. If the commission substantiates an allegation of noncompliance with 935 CMR 500.181A at 1.181, a host community shall be fined after first receiving notice and opportunity for corrective action pursuant to 935 CMR 500.310 and 935 CMR 500.320. A host community shall be fined in an amount equal to the annual total of a CIF's received community impact fees received from all marijuana establishments and MTCs operating in the host community during the prior calendar year. A, the commission shall afford a host community a right to hearing pursuant to 935 CMR 500.500. All fines collected shall be deposited into the Cannabis Social Equity Trust Fund established in Section 14A of Chapter 94G. C, the commission may publish a list of any municipality or host community that has been assessed a fine for equity noncompliance. And D, fine assessments pursuant to this section shall take effect no sooner than May 1st, 2025. Now, one of the things I wanted to point out, and I've raised this in other conversations, that we are still trying to figure out this enforcement. And so, even though we have put out a memo, even though there was a July 1st deadline for participants, or for host communities to incorporate social equity into their host community granting rubric, we don't have the ability. Department of Revenue is not yet set up. So I don't know if at this point in time, I'd mentioned it before, that we might want to, reiterate, state, put it in the record that any interested person isn't going to walk down to, Lennox and say, you're not meeting the social equity requirement. It's July 1st. I want your money to be taken away. So I sort of throw that out there right now. I've raised it before. Again, it's why we have deadlines, and we were behind the 8 ball. We were very late in getting that memo out to the municipalities before the July 1st statutorily imposed deadline. So I just want to, I don't know what I'm asking right now, but I want us to have some understanding and consensus that in terms of enforcement, even though there's a July 1st deadline regarding social equity, that in terms of enforcement, it's going to take a while for that system to be put in place. And, I'd ask for, any comments from my fellow commissioners, because, I've heard people say, well, they knew about this deadline back on July 1st, but they were waiting, back on, August of 2022. But the fact is they've been waiting for us, and we didn't get it done, I think, with enough time to allow this whole process to be set up with DOR and how those penalties are going to, and again, if you think I'm all wet, I'd love to hear your comments back, but I worry that any interested person filing a complaint on July 1st, when we haven't, and Department of Revenue hasn't fully vetted the sort of carrots and sticks and how we're going to enforce this, I'm worried about that. So I'd love, feedback from other people.
I want to make a couple comments. Thank you, Madam Chairwoman. I want to make sure that it is really clear to anybody who's watching that, as you mentioned, the Department of Revenue plays a major role here in enforcement. So we, even though in our regs right now, what we just read is talking about fine assessments being taken place after May 1st, 2025, that doesn't preclude or stop or prevent the Department of Revenue from actually enforcing today if they really wanted to. So I don't want any municipalities that are watching or may watch in the future this meeting to believe that because the CCC has our 2025 deadline in place or proposed and to be in place by these draft regulations, that they in fact cannot be penalized for not having the requirements that were necessitated under law on July 1st. So that's what I wanted to say. Also, to just add another thing, the memo that we developed, and Madam Chair, I know you put a lot of work into this memo. I hope that it is utilized because there's a lot of helpful information there. It's a guidance. It's to assist. But that was not a requirement by the commission under law. That was something that we felt was important to do in assisting municipalities and host communities. So I just wanted to say those couple words.
And I think we did it. And again, just for the public, we did it because there are two deadlines that probably should have been in sync. One is November 9th for us getting these regulations. One was July 1st, putting a responsibility onto municipalities. Yet again, devil's in the details. What is that process under which communities can be penalized? You are responsible for it, and maybe it's going to take some time to hold people accountable. you're on the hook. You're a community, you're on the hook. You have to do it. It's why we did the memo with a, to give communities an opportunity to say, this is what we have to be beginning to incorporate. And that is left somewhat open-ended about what is and is not compliant. We are creating the framework for what is absolutely you must do and is absolutely compliant. So anyway, I just wanted to raise that. Any other commissioners here want to raise any questions about that? Okay, moving on. Section 4, equity standards for host communities during HCA negotiations with social equity businesses and licensed applicants. A host community shall prioritize negotiations of HCAs with equity parties. The equity party in a negotiation of an HCA for an application for licensure is a license. Wait a minute. An application for licensure. Wait a minute. I got to start this over. The equity party in a negotiation of an HCA for an application for licensure is a licensed applicant that has been designated as a social equity program participant, an economic priority applicant, or both. The equity party in a negotiation of an HCA for an application for renewal of licensure is a social equity business. Again, this is sort of the delineation, between at what stage and where you are. So I would ask, are we good on this, Attorney Lopez? Good, I was going to ask you.
So I think we would want to consider now a third sentence that says the equity party may also be an individual or entity that has been pre-verified pursuant to, and then relate back to that section. And then add to the title of section 4, similar language, but we can work the language out. But if I'm understanding your policy intent to be including that group in the HCA negotiation process, then we would add that.
Thank you. Anybody else, any questions or comments? Hearing none, I'm going to move forward. B, a host community may waive or reduce fees for an equity party to an HCA negotiation, including but not limited to community impact fees, zoning, and occupancy fees. We good with that? We like that? Good. All right, C, required practices. At a minimum, a municipality or host community shall take the following actions during HCA negotiations with an equity party to promote and encourage their full participation. 1, engage in an ongoing dialogue by providing multiple opportunities for discussion and negotiation of HCA terms, including at minimum 2 conferences with an equity party. 2, include any attorney, authorized representatives, or other advocate if elected by an equity party in all negotiation and discussions and conferences. 3, promote language access by providing a certified interpreter or translator to assist an equity party who is a non-English speaker during all negotiation and discussions and conferences. 4, provide reasonable opportunities for an equity party to review a proposed HCA term or condition outside of a negotiation conference, or to seek review or input by a third party of their choice. 5, negotiate the terms of an HCA in good faith, including consideration of flexible terms that may mitigate particular challenges affecting an equity party, such as access to capital, with all terms and clauses conspicuously identified and openly discussed. And 6, allows an equity party to propose an amendment to or seek cancellation of an HCA within 30 days of the date of execution of the HCA. Any comments or questions here? Seeing none, I am moving forward. Prohibited practices. No municipality or host community shall negotiate an HCA with an equity party through the use of undue influence, duress, coercion, intimidation, threats, or any strong arm tactics. 2, no municipality or host community shall threaten loss of an equity party's position in its local application queue or delay to the processing of an equity party's application. 3, no municipality or host community shall compel an equity party to sign an HCA in any manner that conflicts with the practices required in 935 CMR 500.141, subsection 4. Any questions here? Commissioner Roy, I see your hand. Oh, you're muted. You're muted.
I don't have a question on this section, Madam Chair, but I think a few of us are requesting a bio break.
I was about to get to that, so can we get through this last? I was absolutely going to do that because it's a natural break. Attorney Lopez?
Just one note for D3. No municipality or host community shall compel an equity party to sign an HCA in any manner that conflicts with the practices required in 935 CMR 500 1814C. So it's referring back to those steps in C1 through
Okay.
6.
I have CB and they're both crossed out, so thank you. All right.
Okay.
And again, some of this stuff is kind of hard to read. Okay, moving towards that bio break, if we can get through this last section, then we can do that. 5, equity standards for positively impacting communities that were disproportionately harmed by marijuana prohibition and enforcement. A host community shall donate at a minimum 3% each of each community impact fee it receives from a license to the Cannabis Social Equity Trust Fund. B, licensees may satisfy their positive impact plan requirement in part by donating to the Cannabis Social Equity Trust Fund. B1, a licensee must have authorization to commence operations to donate to the Cannabis Social Equity Trust Fund. This is A about the host community donating a minimum of 3%. I will point out that there has been some conflicting interpretation of the
Madam Chair.
statutory. Oh, sorry.
Madam Chair, I'm so sorry to interrupt, but
Sure.
we needed a bio break before we got into the section because I think there's
Fine. All right,
discussion.
then
around this.
so moved. Why don't you move
Okay.
it?
Okay, so moved. Yeah, second.
Okay, moved, seconded. Camargo,
Aye.
Concepcion,
Aye.
Roy,
Aye.
Stebbins.
Aye.
Chair votes aye, unanimously. It is 11:53. We will come back at 12:05. Is 8 minutes enough since we're all home?
Sure, thank you.
Okay, thank you.